Hello, my name is Max Venuti. On behalf of Team Delta members Church, Helton, Hobart, and Schrapper, I will be presenting our screencast, Protecting Intellectual Property, the Patent Process. The screencast will focus on the following major points of discussion: general information, legal requirements, patent application types, and the importance of using a patent attorney. According to the World Intellectual Property Organization, IP is protected in law by, for example, patents, copyright, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. The focus of our discussion investigates the process of protecting intellectual property within the framework of the United States Patent and Trademark Office. According to USPTO, a patent for an invention is the grant of a property right to the inventor issued by the USPTO. Generally, the term of a new patent is 20 years from the date on which the application for the patent was filed in the United States, or in special cases, from the date an earlier related application was filed. Patent laws. The Constitution of the United States gives Congress the power to enact laws relating to patents in Article 1, Section 8, which reads, "Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries." The patent law specifies the subject matter for which a patent may be obtained and the conditions for patentability. The law establishes the United States Patent and Trademark Office to administer the law relating to the granting of patents and contains various other provisions relating to patents. What can be patented? The patent law specifies the subject matter that can be patented and the conditions under which a patent may be obtained. In the language of the statute, any person who invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent, subject to the conditions and requirements of the law. Subject matter criteria. The patent law specifies that the subject matter must be useful. The subject matter has a useful purpose. A patent cannot be obtained upon a mere idea or suggestion. A complete description of the subject matter for which a patent is sought is required. Novelty and non-obviousness. An invention cannot be patented if 1. The claimed invention was patented, described in a printed publication, or in public use on sale or otherwise available to the public before the effective filing date of the claimed invention. 2. The claimed invention was described in a patent issued by the United States or in an application for patent published or deemed as published by the United States, in which the patent or application, as the case may be, names another inventor and was effectively filed before the effective filing date of the claimed invention. Has your invention already been patented? Brainstorming terms to describe your invention based on its purpose, composition, and use. Use these terms to find initial relevant cooperative patent classification using the USPTO website's site search box. A fully outlined search process is available on the USPTO site with specific search directions and video tutorials for your use. Patent application types. Design patent The United States Patent and Trademark Office examines applications and grants patents on inventions when applicants are entitled to them. The patent law provides for the granting of design patents to any person who has invented any new, original, and ornamental design for an article of manufacture. A design patent protects only the appearance of the article and is not structural or utilitarian features. A plat patent is guaranteed by the government to an inventor who has invented or discovered an asexually reproduced, distinct, and new variety of plant, other than a tuber-propagated plant or a plant found in an uncultivated state. The grant lasts for 20 years from the date of filing the application. Utility patents are the most common. The term utility means the purpose or useful function, and a utility patent protects the way an invention is used and works. Utility patents are patents issued by the U.S. Patent and Trademark Office for the invention of new and a useful process. For instance, utility patents may be granted for computer hardware or medications. Utility patents are also referred as patents for invention. Most patents fall into the utility patent category. Approximately 90% of the patents issued by the U.S. Patent and Trademark Office over the recent years are utility patents. These patents are subdivided into mechanical, electrical, and chemical categories. Utility patent applications, provisional and non-provisional. As discussed previously, utility patents represent the most common type of patent protection. Two types of patent applications are used when filing for utility patents are provisional and non-provisional patents. The differences between the two can be explained as follows. A provisional application is a quick and inexpensive way for inventors to establish a U.S. filing date for their invention, which can be claimed in a later filed non-provisional application. A provisional application is automatically abandoned 12 months after its filing date, and it is not examined. An applicant who decides to initially file a provisional application must file a corresponding non-provisional application during the 12-month pendency period of the provisional application in order to benefit from the earlier provisional application filing. A non-provisional application is examined by a patent examiner and may be issued as a patent if all the requirements for patentability are met. Each year, the USPTO receives more than 500,000 patent applications. Most of the applications filed with the USPTO are non-provisional applications for utility patents. A complete non-provisional utility patent application should contain the following elements: utility patent application transmittal form, appropriate fees, application data sheet, specification, drawings, executed oath or declaration, nucleotide and amino acid sequence listing when necessary, large tables or computer listings when necessary. Use of a patent attorney to file is highly recommended. A patent attorney is an attorney who has the specialized qualifications necessary for representing clients in obtaining patents and acting in all matters and procedures relating to patent law and practice, such as filing an opposition. The term is used differently in different countries and thus may or may not require the same legal qualifications as a general legal practitioner. Should you hire a patent attorney or agent? The preparation of an application or patent and the conducting of the proceedings in the United States Patent and Trademark Office to obtain a patent is an undertaking requiring the knowledge of patent law and rules and office practice and procedures, as well as knowledge of scientific or technical matters involved in the particular invention. Inventors may prepare their own applications and file them in the USPTO and conduct the proceedings themselves, but unless they are familiar with these matters or study them in detail, they may get into considerable difficulty. While a patent may be obtained in many cases by persons not skilled in this work, there would be no assurance that the patent obtained would adequately protect the particular invention. An understanding of IP protection through the use of patents in the process of applying for patents is a tool that all aspiring entrepreneurs should have in their toolkit. As we conducted our research, we learned a great deal about the subject. The following sources provided excellent information and would be a great place to start for your own independent research. Thank you.